I'm back.
Testing. Sorry. Right. Hello. I'm rather new to video dating, but I hope this tape will give you a good peek at me and when I'm like straight. What I'm like. Straight away, let me tell you about myself and my favorite hobby. Girls. My favorite hobby, girls, is golf. And I also like to fish skate. To fish, to skate, to windsurf, cook Chinese stamps, collecting pottery, read, write, wrestle, run, row, and I like to make lists. Yeah, really fun to have around. Because if I see something amusing, I'll make a joke about it as quick as that. Flash. But don't worry, if you have a date with me, you'll soon want to be in bed most of the time. Most of the time we'll go to discos because that's when I'm in my best late at night. At my best, late at night, I get quite excitable. So if you'd like a date with me, send your tape through the agency, and I do hope to meet you. And don't mention big tits.
Welcome to Facts or Frauds.
All right. The distinguished Mr. Andrew Perry is here on behalf of Midland Credit. And as I said, each one of these is a bit of a wrinkle. This is another motion to set aside a default. The default judgment entered in this case in the amount of $1,553.62 from Midland Credit against Mr. Cuscard. That was entered on November 25th. It was also set for a summary disposition hearing, and I granted summary disposition as well as the default. The defendant had no defense, and summary disposition was appropriate. The defendant filed a motion to set aside the default, but it was actually also a summary disposition. Mr. Perry, what's your position?
My position, Judge, is that Mr. Cuscard didn't properly file a request to set aside the summary judgment. And I think that's the real issue today for today's hearing, is whether Mr. Cuscard pled a request to set aside the summary judgment, which I don't believe he has.
Mr. Cuscard, one of my burdens as a judge every week is to explain to lay people what summary disposition means. You got sued in this lawsuit. The complaint was filed in March of 2024. You filed, it took a while for them to serve you, but you filed a very brief answer in June saying, I deny responsibility of owing this debt. Then you filed a little more expansive general denial where you denied everything. All right, that gets you past the default, but it doesn't get you past a motion for summary disposition. A motion for summary disposition that they filed says there is no material issue of fact, and the defendant has not stated any defense. They filed a history of the bill of sale and a charge history regarding this credit card. So we had a hearing. So two things: if you had shown up I would have found probably summary disposition for the plaintiff, but you didn't show up for the hearing. So I found summary disposition was appropriate. Probably shouldn't check the default box. So a couple things. Why didn't you show up for the hearing? And in order to set the default aside, you have to set forth a material defense, meritorious defense. So your meritorious defense says you were less than 18 years of age, which is not correct. You were born in 1971, so you weren't a minor when this contract was entered. The contract is void or voidable because we did not have a meetings of the mind, no wet signature. That's not valid. You had a history of charging things on the credit card and paying the charges. They don't need those things. I should not have to pay this debt. The complaint is missing key elements, which is also incorrect. So, there is no meritorious defense. And I don't know why you didn't show up for the hearing in November. So, Mr. Cuscard, what's your position?
Well, my position is that I was having technical difficulties with the Zoom. You know, I'm not one of those savvy people when it comes to tech stuff. And again,
Me neither. Go ahead.
And like I said, you know, I couldn't connect with the Zoom. And as far as like the meetings of the mind thing, like I went through the packet that was sent to me that I eventually got, and I don't see my signature anywhere in there.
Well, you don't have to have your signature in there. You have a history of charging things on the card and then paying the charges.
Your Honor, you keep saying that you don't know that was me. I'm saying that I have been a victim of war. So and again, and I do have a Capital One account, but it's not that account.
Well, they sent numerous monthly bills to your address that was in place in Kalamazoo at that time. So there is a fundamental issue. You moved to set aside the default, but you didn't move to set aside the motion for summary disposition. So summary disposition would enter and did enter because there is no material issue of fact, and you did not state any defense in your answer. You just stated a general denial. So summary disposition entered. In addition, you didn't show up. And then sometime after that, let me see when you filed the motion. The order entered November 25th. And you filed a motion to set it aside on December 9th. So it was within 21 days of the entry of the default. But I don't know what to say about technical difficulties. People have them all the time. People do have the right to just come into the court.
And Your Honor,
so let's assume technical difficulties is a legitimate reason. You still haven't stated a valid defense that you owe the debt. So,
excuse me, Judge Middleton. The very first court date I had, I showed up to the court, right? And whatever it went, however it went, and you know that day I was informed, hey, you didn't have to come all the way down. You could have done this by Zoom.
Mm-hmm.
So I tried that the second time, and it didn't work for me. And like I again, the whole wet signature thing, and not. The plaintiff not presenting that I thought that was a relevant defense.
Well, maybe in 1906 you had a wet signature. In the current era, things are all done electronically. And you pled in bad faith that you were 17 years old when this was
17.
entered.
No, I didn't say 17. I'm not 17.
Well, you said that you weren't a minor. You were a minor when you entered into this.
Oh, that must have been a mistake, man.
All right. And then secondly, there is no such thing as a wet signature. I'm not sure if you read that on the internet or somebody told you that.
Yeah.
That's not a thing. Summary disposition entered. You filed an answer that said, hey, I don't owe this debt.
Yeah,
And then you filed a more expansive answer that said, hey, I don't owe this debt.
All right, man.
That's not a defense.
Okay.
So for the reasons stated on the record, the motion is denied. Again, I don't have to like this.
Yeah.
And I guess it's my own fault. I just should have just checked the summary disposition box. Because this was summary disposition. Yes?
Even if Mr. Carissaexplainsitall appeared at the pretrial and our motion for summary disposition, he failed to file a written response to our motion. And when we file a C10 motion, Judge, under G4, he's required to file a response and allege an issue of fact for trial, which he failed to do. So he didn't even do the first part, and he didn't show up. So I would argue, Judge, that even if Mr. Carissaexplainsitall appeared at the hearing that was set for motion for summary disposition, he didn't meet the requirements of G4 and raise an issue of fact for trial. So
that was
summary judgment would have been
earlier. You stated it more eloquently. Even if you had showed up, Mr. Carissaexplainsitall, you would have lost. And you did lose because I entered a summary disposition motion. So you owe this debt. I don't have to like it, but your motion for summary disposition is denied.
Well, I got something to say. I have something to say, man. And all these predator collection companies, man, Your Honor, man, taking advantage of people who have no knowledge of the law. Now that's the real issue.
Well, I guess I don't have, I tell you, I don't have to like it, but that is what the law is. I don't just pull out of a hat.
Buying things, pennies on a dollar.
Good luck. All right. Mr. Perry, I've signed the order denying the motion to set aside default. Because it's a summary disposition is still in effect. Summary disposition stands.
thank you, Judge. It was good to see you. Have a great day.
Hi. Well, that's just about it. So, thanks for watching. And we'll see you again real soon.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell. Also, leave a comment in the comment section. Tell me what you think.
Actually, I wish you could see the studio floor right now. There's nowhere more fascinating after a show. Everyone's so busy. Like bees or...
And a huge thank you to all of our Facts or Frauds channel members. If you'd like to become a member, click on the link in the description or click join right next to subscribe.
There's electricians all rolling up their cables. Whoops! Sorry, guys. And there's the sound technicians unplugging all the microphones. Okay if I keep mine on for a minute, Nobby? Stand up.
Now, if you're still hanging out, thank you. I appreciate you all. Why not hit the thumbs up button, make sure you're subscribed, ring the bell, and leave a comment in the comment section. Tell me what you think. Until next time, I'll see you soon.
And of course, there's lots of the producer's friends, all excited, waiting to meet the stars and generally getting in everybody's way. Just like our producer. Oh, we don't mind. Oh, and not forgetting the prop guys. They're busy striking the set. That's an interesting little point there. Striking. That's a word we all use in the biz for dismantling the set. Taking it apart, unscrewing things, releasing safety catches, that sort of thing.